When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see it tapping and nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you're always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard, magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Daniel. That's why you're always there. When the screen goes dark and the world won't start, I know who to call, yeah.
All right. Welcome to the show. Today is Judge Washington, and she's a pretty good judge. I like her. And next week it's going to be the opposite. It's going to be different judges. So I'm trying to switching it up a little bit. So, it's not the same thing over and over and over again every week. It's the same 6 judges. So here we go. Let's get this started. And let's make this bigger.
I'm trying to put this. I'm sorry, my name is Holly Turner. Take care.
Thank you so much. We're here today for
Thank
a pre-trial in this matter. Is that correct?
Yes, we are. I recently received the evaluation that the people requested at the time of our last appearance. I reviewed it and sent it to Ms. Woods this morning. So we need a new date to allow, of course, time for Ms. Woods to review it and extend any offer that the people are going to extend on the matter.
Thank you so much. Is that a correct statement, Ms. Woods? That you need time to review it, correct? You're muted.
I'm sorry, Judge, I couldn't hear what he was saying.
He was saying that you need time to review the assessment that he sent to you.
Oh, yes, he just sent it over this morning, Judge, so I would need time to review that.
Okay.
Thank you.
So does October 23rd work with your calendar, Mr. Sinclair?
1 second, please.
Of course.
No, I'll be in trial on the 23rd if there's another date available.
How about the 30th, Mr. Sinclair?
It should work. Yes.
Okay. All right, then we'll set it for October 30th, 2025 at 9:00 a.m. Bond will continue and I'll see you all then.
All right, thank you.
Thank you. You have a good day too, Mr. Sinclair.
Thank
Bye.
you.
Quote call case of the state of Michigan versus Megan Maxon, case number 25S00142.
Tiffany Woods for the people.
Good morning, Your Honor. Michael Vincent, on behalf of Ms. Maxon, who is sitting next to me. State your name to the judge.
Megan Maxon.
Good morning, everyone. We're here for an adjourned pretrial in this matter.
Yes. I'm unaware if there are any plea offers from the prosecutor. If there are, we would avail ourselves of one.
Judge, so the plea offer in this case would be a plea to an added count OWVI.
What if you were prepared for all those interview curveballs?
Operating while visibly impaired, Your Honor.
Thank you.
Ms. Maxon, are you prepared to plead guilty to that?
Is that what we talked
Yes.
about?
Yes.
Okay. Yes.
We're ready to enter a plea, Your Honor.
Thank you, Ms. Maxon. It's my understanding you'll be pleading guilty to an added count 2 of operating while visibly impaired. That is a misdemeanor, carrying a maximum penalty of up to 93 days and/or $300 fine plus court costs. The difference is that the points are lower on that, and the maximum penalty in terms of the fine is a little bit lower, but they're both still misdemeanors. Count 1, the more serious one, would be. Is that your understanding of the agreement, ma'am?
Yes, Your Honor.
And that's what you want to do?
Yes.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Ma'am, I'm going to go over the rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay? I need you to answer.
I'm sorry. Yes.
All right. You have the right to have a trial by a judge or a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself. Or you could choose to remain silent. And if you did choose to remain silent, the prosecuting attorney could not comment on that. And in addition to that, you have the right to be presumed innocent unless the prosecutor can prove you guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
You understand you're going to be giving them all up, and there's not going to be a trial of any sort.
Yes.
And if you were on probation, parole, or bond at the time of this particular offense, you could be in violation of it.
Yes.
And the date of this offense was November 28th of 24. Were you on probation, parole, or bond on that date?
No.
All right, good. And then in addition to that, there's no automatic right to appeal the decision you're making today. So in all likelihood, this decision is going to stick with you. You understand that part?
Yes.
And if you're not a U.S. citizen, there could be immigration consequences. Do you understand that as well?
Yes.
All right. To the charge of operating while visibly impaired, how do you plead?
Guilty.
Anyone promise you anything other than what we just placed on the record to get you to plead guilty?
No.
Anyone threaten you in any way, shape, or form?
No.
All right. So on or about November 28th, 2024, were you operating a motor vehicle at the vicinity of I-94 and Rawsonville Road here in Ypsilanti Township?
Yes, I was.
And while you were operating that motor vehicle, were you under the influence of alcohol?
Yes.
All right. Madam Prosecutor, was there a BAC test done?
Your
Yes,
Honor,
Judge.
we'll stipulate to .11.
It was 0.117, Judge. Thank you.
All right, thank you. I find that there's a factual basis for the plea. It has been willingly and knowingly made. Are you guys Well, let me do it more professionally. Ms. Woods, are you satisfied?
Yes, Judge.
Mr. Vincent?
This guy here in Ypsilanti is satisfied, Your Honor.
All right, sentencing in this matter will be on November 6th. Does that work with your calendar?
Yes.
November 6th, 2020. November 6th, 2025 at 10 o'clock a.m. Ma'am, you need to make and keep an appointment with the probation department. Given the plea that was made, does that mean that an assessment has already been done?
I do not believe so.
Which one
Okay.
was?
What did you? Were you assessed anywhere?
I did have
Where?
an assessment done. It was Matt Stabman. Yeah.
Yeah, that's it. Stabenow.
Okay, good. Please make sure that that particular assessment is provided to the probation department, and that will expedite things for her. And then she'll need to contact the probation department. Everybody on the call, everybody on the call, everybody on the call, please write down this phone number right now. Let me know when you have a pen, or if you're going to write it down for your client, Mr. Vincent. I'm going to give them the probation number.
Yes.
All right.
My brains are here. Ellie, she is going to handle all the difficult stuff.
All right, everybody on the call, please write down this phone number, 734. I want to give it out once this morning, so if I ask, you should have written it down. 483-7336. If I ask and you haven't written it down, I am not going to be happy.
We are very happy here, Your Honor.
Thank you, good. All right. Then I will, and I can see people, and I can see who's not writing it down. So I will see you, Ms. Maxon, on November 6th at 10 o'clock a.m. Count one is dismissed.
And Your Honor, briefly mentioned, she does have a medical marijuana card. She's provided a doctor's letter to community
Yes.
corrections.
Yes,
Yeah.
and I approve that.
Thank you.
You're welcome. You're all set. I'll see you later. All right, the court will call case of the state of Michigan versus Yusuf Gaslawi, case number 25S00304.
Tiffany Woods for the people.
Amir Al-Khalidi for the defendant, Mr. Al-Ghazlawi.
Good morning, Ms. Al-Kidi.
Good morning. My name is Yusuf Aslawi.
Thank you. Good morning, Mr. Gaslawi. We're here today for a pretrial.
This is the most advanced fleece ever invented. That's because bear.
That's correct, Your Honor. I am just waiting to get a chance to speak with the prosecutor to see if we can get an offer on Mr. Al-Ghazlawi's.
All right, we don't do breakout rooms here. We have one prosecutor. We're not going to stop the docket for people to talk to the prosecutor. That has to happen before pretrial. If you want to email her or chat with her, I can pass it while you do that. But otherwise, maybe she has an offer she wants to put on the record. I'm not sure.
Judge, I do have an offer in this case, and it would be to careless driving.
Okay. Judge, can you give us a brief adjournment in this matter?
Of course. Does October 23rd work with your calendar, counselor? That'll be at 9 a.m.
Yeah, well.
I'll make that date work, yes.
All right. October 23rd, 2025 at 9 o'clock a.m. Bond will continue. And
Okay.
I'm noting that the offer is for careless, which is a civil infraction.
Okay.
We'll see you all back here on October 23rd. Okay?
Thank you, Judge.
Thank you. Have a good day.
You too.
Court will call the matter of the state of Michigan versus Clarence Benson, case number 20S00677.
Tiffany Woods for the people.
Good morning, everyone. Allison Muller here on behalf of Clarence Benson. Mr. Benson, can you state your name?
Clarence Benson.
Thank you. Good morning, Mr. Benson. We're here for an adjourned pretrial.
Yes, Your Honor. We have spoken with Mr. Benson. We've gone over the the offer from Miss Woods, which Miss Woods, the offer was to plead to OWI first offense, correct?
That's correct.
And with that was also with the referral to probation and an agreement to no upfront jail.
Yes.
Thank you. Your Honor, Mr. Benson would like to accept that offer and move forward with the plea at this time.
Okay, I'm writing it up.
Thank
Yeah.
you.
You said it was OWI first. Count 2 of OWI first, referral to probation. And no upfront jail. Is that correct?
That's correct, Your Honor.
Anything else?
No, Your Honor.
All right, thank you. Just want to make sure I got it all. You said after the fact that he was accepting it, so I wasn't right.
Okay. Sorry, I'll lead with that.
All right, thank you. All right. Sir, it's my understanding that you're going to be pleading to an added count 2 of operating while intoxicated first offense, which means that count 1, operating while intoxicated second offense, will be dismissed. There will be a referral to probation, and there's an agreement that there will be no upfront jail. Is that your understanding of the agreement?
Yes.
And is that what you want to do?
Yes.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over the rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your counsel again, okay? Okay. I need you to answer out loud, sir.
Yes.
All right, thank you.
Yes.
All right. Yeah, I think there's a delay. I think that's what the problem is. You have a right to have a trial by a jury or a judge, at which time you can call witnesses to speak for you. You can get an order signed by me to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you understand that you're going to be giving up each and every one of those rights and you're not going to be having a trial of any sort?
Yes.
Do you also understand that there's no automatic right to appeal this decision? So the decision you're making today, in all likelihood, sir, will be sticking with you. Do you understand that?
Yes.
And if you were on probation, parole, or bond when this offense occurred, which was on July 12th of 2020, and if you're still on that same probation, parole, or bond, you could be in violation of it. Were you on any probation or parole or bond way back then that you're still on now?
No.
All right. And if you're not a U.S. citizen, you could have immigration consequences. You understand that?
Yes.
All right. To the charge of operating while intoxicated, how do you plead?
Guilty.
Anyone promise you anything other than what we just put on the record to get you to plead guilty?
No.
Anyone threaten you in any way, shape, or form?
No.
All right. On or about July 12th, 2020, were you operating a motor vehicle at the vicinity of 3375 East Michigan Ave here in Ypsilanti Township?
Yes.
And while you were operating that motor vehicle, were you under the influence of alcohol?
Yes.
All right. Was there a BAC, Madam Prosecutor?
Yes, Judge, the BAC was 0.219.
Defense stipulates to that result.
Thank you. I find that there's a factual basis for the plea has been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is also satisfied.
Thank you. All right. Sentencing in this matter will be on November 6th, 2025 at 10 o'clock a.m. Sir, did you write down the phone number when I gave it out earlier?
Yes, I got the phone number. I called yesterday, and they told me to call back today.
Okay, great. Then I will see you back here on November 6th, 2025 at 10 o'clock a.m. for sentencing, okay?
Okay.
Count 1 is dismissed. Have a good day, sir.
You too. Thank you.
And make sure they'll schedule for you to get that assessment done if you haven't had one. So make sure you comply and get that assessment done before you come back. Okay, Mr. Benson?
Oh, no, I had one done.
All right, good, perfect. Thank you.
I'll get that to probation.
Okay, thank you. Well, we'll call the case of the state of Michigan versus Donnell Fonville, case number 25S00386.
Tiffany Woods for the people.
Sorry about that. Allison Muller here on behalf of Donnell Fonville. Mr. Fonville, can you unmute and state your name?
My daughter is being treated for leukemia. It hit me hard. It did.
Mr. Donnell Fonville,
Yeah.
unmute your device, turn on your screen and state your name.
All right, can you hear me?
I can now, yes, thank you. Please state your name.
Donnell Fonville.
Thank you. We're here for a pretrial today.
Yes, Your Honor, and I believe we called Mr. Fonville and hopefully explained this, but our office does have a confirmed conflict. This was just confirmed yesterday by my management, yesterday at 4:40. So all that paperwork should be coming so that Mr. Fonville can be assigned a new attorney.
A new attorney for what?
She just told you, sir, that there's a conflict in this case, meaning that I don't know, did you represent someone else or what would be the conflict?
Your Honor, there's another party. Let me see.
Judge, before this goes any further, this case needs to be nollie-prossed. Do we need to have a new attorney for that, Judge, or can I do that?
You can nollie-pross. We don't have to have an attorney. You're going to submit the documentation?
Yes, Judge.
Hey, Your Honor, what do that mean?
Okay, what that means, sir, is apparently they believe that probably what you told the magistrate is correct. There's some reason why they can't proceed with this case against you, so they're going to dismiss it.
Thank you.
All right. All right. The case is now dismissed. Counselor, please submit the documentation so I can sign the order dismissing it.
Yes,
All right.
Judge, I will. Thank you.
You're all set, sir. This case is now over. Have a good day. Take care of yourself.
Appreciate that. Thank you.
You're welcome.
Yeah, it's not easy. Hello, y'all still there?
Yes, we're still here. We'll call the case of the state of Michigan versus Randy Ward, case number 25S00166.
Tiffany Woods for the people.
Allison Muller here on behalf of Randy Ward. Mr. Ward, can you state your name?
Randy Ward.
Thank you. Good morning. All right, we're here for an adjourned pretrial in this case.
Yes, Your Honor, and there is an offer here from Ms. Woods that we would like to accept and move forward with today.
All right. You may proceed.
Your Honor, the offer that we'd be accepting is to plead as charged to count 2, dismiss count 1, and my understanding is there's an agreement to a prosecutor's deferred as to count 2 with the referral to probation. Ms. Woods, is that a correct statement of the offer?
That is correct.
Thank you. All right, sir, it's my understanding that you're going to be pleading to Count 2, which is breaking and entering illegal entry without owner's permission. And count 1, the larceny, would be dismissed. Count 2, which is illegal entry, is a misdemeanor. It carries a maximum penalty of up to 90 days and or $500 fine plus court costs. In addition to that, the prosecutor would place you on their prosecutor's deferred. And if you do everything you're supposed to do while you're on that particular deferred, at the end of it, it will no longer be on your record. So this charge will not be on your record. And probation would be determined the length of that probationary term because it would be a referral. Is that your understanding of the agreement, sir?
Yes, ma'am.
And is that what you want to do?
Yes, ma'am.
All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be with the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. May lower your hand. I'm going to go over the rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Yes, ma'am.
You have the right to have a trial by a jury or a judge, at which time you can call witnesses to speak for you. You get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor couldn't comment on it. In addition to that, you have the right to be presumed innocent unless the prosecutor can prove you are guilty beyond a reasonable doubt. Do you understand those rights?
Yes, ma'am.
You understand you're giving up each and every one of those rights and you're not going to
Yes,
be having a trial of any sort? Okay. And do you also understand that there's no automatic right to appeal this decision? So in all likelihood, the decision you're making today is going to stick with you.
Yes, ma'am.
If you were on probation, parole, or bond when this happened on April 17th of 2024, and you're still on that same probation, parole, or bond, you could be in violation of it. Were you on any of those?
No, ma'am.
And if you're not a U.S. citizen, you could have immigration consequences. You understand that?
Yes, ma'am.
To the charge of breaking and entering illegal entry without owner's permission, how do you plead?
Guilty.
Anyone promise you anything other than what we just put on the record to get you to plead guilty?
No, ma'am.
Threatening you in any way, shape, or form? Is anybody doing that?
No, ma'am.
All right. So on April 17th of 2024, were you at the vicinity of,
1269 Wendell.
thank you, that's here in Ypsilanti Township?
Yes, ma'am.
And that's a yes, you were there?
Yes, ma'am.
And at that time, did you enter into those premises without getting permission from the owner?
Yes, ma'am.
All right. Who lives there?
My brother-in-law.
Oh, okay. What happened?
Hi.
These glasses destroyed a multi-billion-dollar industry. Nobody believed me at first, but now everybody wants them.
What happened, Mr. Ward?
Huh?
What
Oh, I
happened?
was high on crack cocaine.
Oh, and so you just you broke in there with it. Like, did you go through the door? Like, what did you do?
I had a key.
Oh, but he didn't give you permission to come in that day?
Yes, ma'am.
Okay. Thank you. All right, I find that there's a factual basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is also satisfied, Your Honor.
I'll schedule sentencing for this matter on October 30th, 2025 at 10 o'clock a.m. Mr. Ward, did you write down the phone number when I handed it out earlier?
No, ma'am. My lawyer texted me it last night.
Thank you. So please call the probation department tomorrow after 9 o'clock a.m. Schedule a time to have your pre-sentence investigation interview done, okay?
Yes, ma'am.
All right. You're all set. Make sure you have that done and we're ready to go when you come back here on October 30th. Count one is
Yes.
dismissed, so,
And Your
Yes,
Honor,
ma'am.
yes.
I think we've talked about this on the record before, and I know Mr. Ward will discuss this with probation, but he does, since this case has been ongoing, he's been living in Tennessee. So just as a, he does live there, so he'll be participating on everything over Zoom, but should have no issue with probation, contacting them and getting everything set up.
Thank you so much.
Thank you.
You're all set, Mr. Ward.
Thank you.
Thank you. Have a good day.
You too.
Thank you. We'll call the matter of Patricia C., case number 25S00286.
Tiffany Woods for the people.
Allison Muller here on behalf of Patricia C. Your Honor, we do have Miss C's legal guardian, Miss Spencer, if she would be allowed to state her name. I think unfortunately, and hopefully we'll be able to provide some information about this, I do not believe Miss C herself is on Zoom today.
My name is Jean Spencer. I am legal guardian for Patricia C.
Thank you. Good morning, Ms. Spencer.
Good morning.
All right. So what is going on? Where's Miss C?
Your Honor, Miss Spencer, her guardian's been trying to get a hold of her this morning. Miss C does have some underlying health issues, including, I believe, a dementia diagnosis. So that is, I believe, the reason that she's, kind of forgotten about the court date and is not on today. Miss Spencer and I are going to work together and hopefully get some documentation about her diagnosis. Miss C is also living in a permanent group home, so I'm going to get documentation of that to provide to Miss Woods. And hopefully we can, get her on Zoom if the court would give us a new court date and also work towards a resolution on this matter.
Response from the people, please. Ms. Woods, do you have a response?
Judge, I would have no objection to allowing time to gather that information. I would like to know what's going on as well.
All right, thank you. October 23rd, 2025, at 9:00 a.m.
Yes, Your Honor.
Bond will
That's good.
continue. I'll schedule that for a show cause and a pretrial. So please get us those proofs so we can know what's really going on.
Of course, yes.
Thank you. Take care.
Thank you. Have a good day.
I'm up here. You too. I'm sorry. Oh, that was me. Okay. Thank you. What will call the case of what will call the case of Christopher Greer, case number 25S00063.
Tiffany Woods for the people.
Hey, Your Honor, good morning. Good morning to you and your staff. This is Matthew Mansour, Assistant Public Defender, on behalf of Mr. Christopher Greer, who appears today via Zoom. Chris, can you please unmute and state your name?
Christopher Greer.
All right, we are here today for a pretrial as well as a bond violation.
That is correct, Your Honor. And Your Honor, if we could approach just briefly.
Thank you. Along with Ms. Muller. I want to see Ms. Muller, so I want Ms. Muller to come in.
Okay.
Thank you.
Stop buying generic Viagra if you're over 60. You qualify for 9 tablets of 100 milligrams.
All right, we're back on the record in the case of the state of Michigan versus Christopher Greer. Mr. Greer, I'm going to arraign you at this time on the violation, which indicates that you blew a .032 on September 24th, 2025 at 9:46 p.m. and you were supposed to keep retesting until you blew at 0, but you didn't do that. You have a right to have a hearing on the violation. At which time, if it is shown that you did blow, or if you admit to it, you could have your bond revoked. Do you understand that, sir?
Yes, ma'am.
And it's my understanding you're going to waive your right to have the hearing and you're going to admit to the violation?
Yes, ma'am.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So you can lower your hand. Blew a .032, sir?
Ma'am.
I'm sorry?
Yes, ma'am. I was sick. And what I did, I
Hold on,
made
Mr. Gray. Hold on, Chris. She's gonna give you a chance.
I'm sorry.
It's okay.
Thank you. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is satisfied, Your Honor. Thank you.
Thank you. Now, what do you want to say about why you blew a .032, sir?
I
And
was under the, ma'am.
be careful about what you say, because what you're saying is going to sort of define what happens next.
I was in the wrong. I apologize to the court and to the people. There's no excuse.
I think you were about to explain how you were under the weather, and so you were drinking something to help with that. I'm hoping that you don't say that, because that
No,
sounds
ma'am.
you're not accepting that you have a real problem with alcohol.
No, I wasn't going to say that.
Okay, what were you going to say?
I was just under the weather real bad.
Okay. Well, you need to accept where you are with this disorder that you have, sir.
Yes, ma'am.
The sooner you accept that, the better off you're going to be. So I'm going to condition, because I have two options right now. I can give you another chance, or I can just put you in jail until we figure out what to do. I'm going to give you the opportunity to get into a recovery court and
Yes,
into
ma'am.
that Mr. Mansour was talking about. So you need to do the programming until you can start the recovery court, assuming they accept you, of course. Okay.
Yes, ma'am.
So I'm going to request that I get some proofs. One, that you've done the referral and you're working on getting into recovery court. And two, that you're in the program that he talked about, which was just an added programming that they have over there at 36.
Yes, ma'am.
You need to continue to comply with your bond requirements and not have another single positive. Another positive, sir, and you leave me no choice. You're going to go to jail. So I'm not going to revoke your bond at this time. What I'm going to do is to hold that in abeyance to make sure that you're doing what you're supposed to be doing. Okay?
Yes, ma'am.
So the choice is up to you. And
Yes,
if
ma'am.
you need help, what I would suggest you do is also, and I don't know if the programming requires this, but you also get into some AA courses, AA meetings, and start trying to get a sponsor who can help you through times when you have that urge, because
Yes,
some
ma'am.
just can't do it by ourselves. All right.
I understand. Thank you.
Well, and you maybe shouldn't thank me just yet. You got to make sure you put in that work, because now
Yes,
it's
ma'am.
all right. Bless you. October 30th, I think should be enough time for us to get the referral over and have an answer from them.
And this referral is going to 36.
That's correct.
Yes, ma'am.
Your attorney and the prosecutor and I have talked about the steps that the two of you need to take to try to make sure that referral gets to them. And we're going to do that. And you need to continue with the programming.
Yes, ma'am. The program that I'm attending now,
Yeah. What is it called, Mr. Mansour, so we can be clear?
Called Care First Community Health, I believe. Care
Yeah.
First Community Health.
You're in that program, sir?
Yes, ma'am. Mondays.
You need to provide those proofs. They give you a sheet, a sign-in sheet. If you're in person, if you're
Yep.
on, then you have to do whatever it is they require for you to get proof that you were on a Zoom meeting.
Yes, ma'am.
All right, I'll see you back here, sir, on October 30th, 2025. Your bond is continued. Revocation of the bond is under advisement. So you'll help me decide whether your bond gets revoked or not. Okay?
Yes, ma'am.
All right. Good luck to you, sir.
Yes, ma'am. Thank you.
All right. Thank you.
1 second, you're not there. And then, right on time, your neighbor is. Feel secure.
Phone call the matter of the state of Michigan versus Ryan Winborn, case number 25-00364.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Ryan Winborn. Ryan, can you please say your name?
Ryan Winborn.
Thank you. Good morning, Mr. Winborn.
Good morning, Your Honor.
How are you?
Good, and yourself? I just want to say it's a pleasure to meet you. I've watched your videos before, so I just want to say hello.
Thank you. I appreciate that. All right, we're here for a pretrial in this case.
Yes, Your Honor, that is correct. I've sent over some information to Ms. Woods. I would like her to review. It could potentially resolve this case, hopefully on our side, but we're just going to ask for a short adjournment to allow her to review the documents that I've sent over and come back, and then we'll see where we're at.
Thank you.
That is correct.
October 23rd or October 30th, Ms. Woods, since you have to do the review.
Judge, either of those dates would work for me.
October 30th, 2025 at 9 a.m. Bond will be continued, sir, and I'll see you next time. Okay?
All right. And that was October 30th at 9 a.m.
October 30th at 9 a.m. Have a
All
good
right. And I did write down that number.
All right, good. You don't need it today, so there's that. All right?
All right. Bye-bye.
Have a good day. Bye.
You too.
All right, the court will call the case of the state of Michigan versus Timothy Becker, case number 25-00149.
Tiffany Woods for the people.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Becker. It's a pleasure to meet you for the first time as well, Your Honor. Mr. Becker, if you could please state your name for the court.
Timothy Becker.
Thank you. Good morning, Mr. Becker.
Good morning.
All right, we're here for sentencing today. Have you had a chance to review the pre-sentence investigation report with your client?
Yes, Your Honor. I have no corrections to make to the body of the report. Just a couple of things to say by way of allocution and the recommendation at the appropriate time.
Thank you. Ms. Woods?
Judge, I've also had an opportunity to review the PSIR recommendation, and I'm fine with the recommendation. However, I just want to make sure that there is some mention of mental health. So I'd ask for a mental health assessment and restitution reserved for the tire for the malicious destruction of property. There was some restitution that the victim is also asking for as well. So I'd ask for it to be reserved for 60 days.
Thank you. I do note that she's asking for a restitution with respect to 2 tires because apparently they told her that they would only replace 2 at a time for balancing issues, and they refused to do 1 tire. So I think that we should just make note of that right now, and then I'll allow Mr. Bernstein to say whatever he needs to say.
Yes, Your Honor. A couple of things to tell the court. We don't have any issues with the restitution request. If the probation department wants to just send that over when it comes in, and I'll share it with Mr. Becker, but I don't anticipate that'll be an issue. Mr. Becker does want to tell the court that he is sorry for his actions. He has no way to describe what happened other than that he handled himself very poorly. He wants to know that he is 40 years old and he's never been in trouble before, never been charged with a crime before. The PSI notes, and Mr. Becker recognizes that he has several diagnoses of psychiatric, like disabilities, and those have been there since high school. He is well aware of them. He has chosen to live a lifestyle that involves being medication free for that and for not being under the treatment of a doctor. And that has worked out for him his whole life. He lives a very quiet life with, Judge, are you still there? The screen went blank.
You may proceed. I'm listening.
Oh, okay. You went off the screen. So, yeah, I mean, he's lived a quiet life. He's never really been in such a situation before as this before. And I don't think he understood or knew how to really best handle it. He was at a gas station. All of a sudden, a stranger came up to him and just started yelling. I mean, it was just one of these kind of road rage, I was cut off in traffic, so I'm going to yell at you type situations. And he just didn't know really the best way to deal with it. And the way he dealt with it was not obviously the correct way to deal with it. I mean, he should have just walked away, but he didn't really know. And that was just something really shocking to him. And I've talked to him a couple of times, and he didn't really know how to act when that stressor just hit him right then and there. But it looks like in the PSI, he notes that he's sorry. He knows he handled it poorly, and he wishes that he could take it back. I understand there is a request for a mental health assessment and to follow all recommendations from that. That is kind of a point that I want to address. I don't know what those recommendations might be. I don't know that this is a point in time where he needs to change who he is necessarily in terms of how he treats his own condition. He's been able to manage his own, I hate to call it conditions, but his own disabilities, and he's been doing it effectively for 40 years. And I don't know that this situation was necessarily the result of those conditions outside of maybe not having the tools to really deal with it, just given who he is and maybe never being in that situation before. But I don't necessarily want this to be a point in time where he's fixing things that don't need to be fixed. And he's made a decision in his life not to work with doctors about his disabilities. He's made a decision not to take medications. And he would like to continue on that path, Your Honor. And so his concern is that the mental health assessment might change what he's doing and change who he is. And so we are asking the court to reconsider that requirement of probation, Your Honor.
Are you wearing 7 layers and still freezing your man nipples? You need the new 300.
Judge, I'd like to just step in here for a second. He's not managing his condition well, which is why he is where he is today. He stole someone's parking spot at a gas pump. Then when he was confronted about that, he pulled a knife out, threatened to slash her throat with the knife, then went outside, slashed her tire, and spit on her face. That is not something that a reasonable person would do. I believe that he does have a mental health condition, and I believe that a mental health assessment would be appropriate and is needed. A lot of people that are in his situation refuse to take medications because they're in that situation where they're mentally ill. That's maybe what's going on here. I don't know, but we're not going to know anything unless we get that mental health assessment. And I believe that he should have that done, and I would ask the court to order that. Thank you.
And Judge, I want to defend Mr. Becker a little bit because I don't quite read the report that way. I mean, we say steal a police report or steal a parking spot. He pulled into a gas pump and someone came and started yelling at him. He left and went into the gas station, and she followed him and kept yelling at him. And then he leaves the gas station and she leaves and follows him and keeps the argument going. I mean, the starting of the fight, the continuation of the fight. I mean, yes, he does escalate it afterwards, but like she keeps following him and yelling at him. I mean, I'm tired of the road rage of stuff that's going on and people just attacking strangers over these things. I'm not justifying in any way. And Mr. Becker doesn't justify what he did. He knows that he handled it wrong. He did, but I just don't agree with the characterization of there. I mean, he's here to take responsibility for what he did, and he pled guilty and he's done that. And I applaud him for doing so. And I applaud him for apologizing for his actions, but I don't know that it just requires a redo of everything in his life and in such an intervention for that purpose.
Right, let's talk about the facts then, since that's what we want to get into an argument about today at the time of sentencing. I think the facts become really important because they diverge. She says that the argument happened outside and that first of all, I'm not sure why he would feel the need to pull a knife on a female. So let's talk about that. And then secondly, she says that he spat on her and the argument was between the two of them. And you're characterizing it as her being the person who was involved in a road rage when she says that he cut her off at the pump. So it could be that his behavior, which is out of control in the first place, caused her to be upset. So why don't we try to figure out more about what happened so we can see what the request really should be, because she would really like for him to do some jail time.
I'm not trying to.
No, we're there now. There's no trying to. We're there now. So
Okay.
let's figure out more info on what happened that day. So Ms. Woods, it sounds like we need to have some further. Is there a video of any of this? What is the bottom line of this?
Judge, I'd have to look at the police report to see if there's a video.
Because first of all, I don't agree that two people in an argument should result in anybody pulling a knife on a female and then spitting on her. That's all problematic to me. And if you think that he's managing well by doing that, I think we disagree.
Well, what I'm saying, Your Honor, and I don't disagree with anything the court just said. I'm just saying I don't think it's necessarily a mental health issue. I don't want to say that.
So it's just character? That's what his character is like?
No, I'm not saying that's his character. I just don't want to start putting him on medication when that's not necessarily called for.
That's why a mental health assessor makes that determination.
Okay, understood.
Apparently the clerk in the gas station says he did not have access to the cameras.
Okay.
Hello. Who's talking? Please mute your device.
Yes, you got to do it like this. Man.
Please mute your device. Yeah, it looks like there's no access to the cameras.
Cole, he's my miracle child. So how does your miracle child?
I believe that's the case, Judge.
Mr. Becker, what would you like to say, sir?
Like what happened?
If you want to address what happened, you can, or you can just address what you would like to say today about this particular incident and what you want me to know before I sentence you.
I'm just like to say I'm sorry for my part. You know, I try to keep myself, away from society, only out, whenever I can. It's not, like, I didn't expect to be, bullied at a gas pump. I could have just walked away, but, her keep, calling me, all sorts of, names. Then threatening me when she walked into the store. That's the only reason why I showed her the knife, to let her know that if she keeps bullying me, that's what was going to happen. And then I walked out back to my car, and she just kept going. I'm just, could have just walked away, but stress, trying to quit smoking, which one more week would be officially a year.
You can on that piece, Mr. Becker.
And wrong place, wrong time.
Well, thank you, Mr. Becker. I mean, I think that for me, a part of what we need to figure out is what you need to not make choices like that in the future, whether it's mental health or whether it's some type of therapy that helps you to decide better courses of action when you do have to be in spaces with other humans. And sometimes the other humans aren't going to behave properly, right? So you got to know what to do when they're not behaving properly. Okay?
Yeah.
All right. Thank you. Give me a moment. I want to talk to your attorney and prosecutor, okay?
Alrighty.
All right. Thank you. You can mute yourself, Mr. Becker. Can I see counsel in a breakout room? And probation, yes.
Ms. Ball, if you can hear me, I accidentally bounced out of the breakout room. If you are able to put me back in.
You don't have to do it.
What if you were prepared for all those interview curveballs?
Any jail time at this time, okay? I need you to follow the court's orders so that we can try to get you the help that you need, okay?
What if you were prepared for all those interview curveballs?
Okay.
All right. You're going to be on probation for 18 months. You'll be eligible for discharge from that probation after you complete 9 months. So if you've done everything you need to do in 9 months, you can be discharged from probation. Fines and court costs in this particular case for a total of $275. Restitution to be determined within 60 days. You to meet with probation when and where directed, including any and all home visits. You must complete a mental health assessment / neurological assessment to help with socialization, okay?
Alrighty.
And you're gonna you need to have that done within 21 days of this sentence, okay? And you need to sign a release of information so that probation can talk to the counselor or whomever's going to do that assessment so that we can make sure we're all on the same page, okay?
Yes, ma'am.
No contact with Stephanie Sakula. No assaultive or threatening behavior towards her or anyone else. You to submit to and be responsible for any random drug and alcohol tests, but none are being ordered at this time. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, or firearm components, or dangerous weapons. And I'm going to see you back in 60 days to see how everything is going with that assessment and what things look like, okay?
Yes, ma'am.
And so I'll see you back here on December 4th, okay?
Yes, ma'am.
Any questions?
No, ma'am.
All right. Did you write down the phone number earlier to call the probation department?
Yeah, I should have it still.
Good. I'm sorry? All right. All right. Mr. Bernstein, can you make sure that he has that phone number if he wasn't on earlier? Okay. Do you have it? You're muted.
Yeah.
I do. Yes, Your Honor. I'll make sure he has it.
All right. Thank you so much. Please call them tomorrow after 9 o'clock, okay?
Yes, ma'am.
All right. Thank you, Mr. Becker.
You're welcome.
Good luck to you, sir.
Thank you, and you too.
Thank you. I appreciate it. I will call the matter of the state of Michigan versus Richard Apperson, case number 25 FB 1083.
He works for the people.
Sherilyn Foster Tucker on behalf of Richard Apperson.
Richard Apperson.
Thank you. We're supposed to be here. Did not schedule assessment done.
Your Honor, I apologize. I'm having a little bit of trouble hearing.
I think it's Mr. Apperson.
Yeah, I muted him.
All right. Mr.
Okay, sorry about that.
Mr. Apperson did not schedule to have his assessment done, so we are not prepared to move forward. Why didn't he do that, please?
Your Honor, I'm not sure exactly what happened. I talked to him and he indicated that he did talk to someone from probation. I will say that Mr. Apperson is currently residing in TriCap, which is in Saginaw, Michigan. It's an alternative to incarceration, but he is in a residential placement right now. He has had a substance abuse assessment done through that, and he gave it to me, which I provided to probation this morning. So I'm hopeful that will help move things along. And then I can help facilitate just getting him in contact with probation. I think there may have just been a bit of a breakdown in communication there. And he is in this residential placement until at least the end of this month. Sometime in November is his.
Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 44.
Anticipated release date.
Thank you. Mr. Pappenhagen, are you present, sir, or you may not be present this morning? We've got quite a few things going on right now. We're moving.
I'm present, Your Honor.
All right. Mr. Pappenhagen, did you receive a copy of the assessment from Ms. Foster Tucker this morning?
I did, Your Honor.
You say you did?
Yes.
And do you find that sufficient? Do you find that sufficient and we can just go ahead and reschedule him for sentencing at our?
Yes, Your Honor.
All right. Then I'm just going to put it on October 30th at this time. Okay.
Okay. Thank you, Your Honor.
That work with your calendar?
Yes, that's fine.
October 30th, 10 o'clock for sentencing. Sir, you still do need to contact the probation department? Okay?
What'd you say?
You can't hear me already either. All right, I'm gonna mute you because you got a lot of background noise there, so you can't hear me. You probably didn't hear that either. All right, sir, we're gonna schedule you for October 30th, 2025 at 10 o'clock a.m. Okay, just nod your head yes if you heard me. He's nodding yes. All right, and get the phone number from Ms. Foster Tucker and call the probation department so that they can schedule a time to have your pre-sentence investigation interview, okay? Thank you. You're all set. I'll see you on October 30th. Bond is continued.
Thank you, Your Honor.
You're welcome. Yeah. The court will call the case of the state of Michigan versus Tanya Hall, 21 FB 1472.
Tiffany Woods for the people.
Good morning, Honor. Robert J. Kill on behalf of Ms. Hall. Tanya, can you get on the screen and state your name, please?
Tanya Hall.
Thank you. Good morning, Ms. Hall.
Good morning.
We're here in this particular matter for a sentencing, and there's also a bond violation report. Are you in receipt of that, Mr. Killawall?
Judge, what would you like to do first, the sentencing?
I want to deal with the bond violation first. Are you in receipt of the report, sir?
I believe I am. Are we talking about a progress report?
We're talking about a bond, community corrections, bond violation report that says that she, let's see, first of all, it looks like she missed her test on August 4th.
That I don't have, Judge.
And let's see. I'm just trying to make sure that Judge Simpson didn't handle any of these. Yeah, it looks like she had a bench warrant for failing to appear at the preliminary examination stage back in July, but I don't see that she was ever arraigned on the violation.
Judge, when we pled on August 28th, I don't, my notes don't reflect any talk of a bond violation.
Yeah. I don't see that either. The report came to me, it's dated September 30th. Which means that it can't speak to whether or not additional reports came out before this time. I can only speak to what I have. which is that on September 30th, it alleges, ma'am, arraigning you on the violation at this time, that first of all, there was a positive cocaine and THC test on June 12th. And then there was a missed test. There have only been 3 testing times. There was a missed test on July 7th and a missed test on August 4th.
I was in rehab then.
Well, I'll let you talk to your attorney about that and he'll explain it to me.
Judge, I'm not aware of the violation report that you have. Is there any?
Have someone send it to you?
Yeah, is Judge, my client's doing really well now. I'm wondering if we could just adjourn this a week so I could speak with Tanya about this.
I'm gonna pass it so that you can go into a breakout room and speak to her.
Okay. Is there? I'm sorry.
The agent, who I'm trying to see, Ms. Dozier, says that she doesn't have a copy of the inpatient treatment either. So, and that her whereabouts were unknown. So we're gonna need proof of where she is. Okay.
Yeah, with the help of the Delana Center, she's now has her own apartment, and I want to congratulate Delana Center for all the good work they've done. And like I say, my client has really turned her life around. But if I could have a breakout room with her, I'd appreciate that.
Thank you. And can we please have someone from probation check to see whether she's tested at all since June of 2025? All right, I'll put you in a breakout room with your client.
Thank you, Joe.
Thank you. All right, I'll pass that matter. The court will call the case of the state of Michigan versus Shannon Remsen, case number 24 FB 1337.
Tiffany Woods for the people.
Is Mr. Rucker present? Counselor Rucker, are you present? Attorney Rucker, are you present? All right, I'm passing that, madam.
You're not a child, you're a man. So stop wearing so many layers to go outside and get.
We'll call the case of the state of Michigan versus Kiera Rolex, case number 25-00366.
Tiffany Woods for the people.
Allison Muller here on behalf of Kiera Rolex. Ms. Rolex, can you unmute and state your name, please?
Kiera Rolex.
Thank you. We're here for pretrial today.
Yes, Your Honor. And Ms. Woods, I believe we just adjourned to find out if restorative justice is an option on this case.
That's correct. And we did hear back from the victim and they do not want restorative justice. And they are cooperative. They are asking for probation and a substance abuse assessment. So our offer is to plead guilty to added count 2, just assault and battery, with no upfront jail, probation, restitution reserved, and a substance abuse assessment. And yeah, that's it. Thank you.
Ms. Rolex, I know we talked about the possibility if restorative justice was not an option. Your wish was to set it for final settlement conference. But do you have any questions given what the prosecutor just put on the record as to offer, or do you wish to move forward as we discussed with final settlement?
Final settlement.
All
Okay.
right. She's rejecting the offer. I think you need to fully explain to your client what the offer is if you haven't done that yet.
Your Honor, if I could just speak with her in a breakout room very briefly, I'd appreciate that.
I'll pass this. What will we call the case of the state of Michigan versus Shannon Remsen, case number 24 FB 1337?
Tiffany Woods for the people.
Mr. Rucker, please place your appearance on the record. Mr. Rucker, please unmute and place your appearance on the record.
Unmute, moron.
Good morning. This is actually Attorney Washington. I'm here with Mr. Rucker over in Hazel Park. He's finishing up a plea. He just asked me to hop on and ask if we could pass this matter for a few minutes so that he can finish up. He's
I
about
had
to be
already
done.
done that, so why would you come? Passing that case again. I'll call it back when I get ready to.
Thank you.
What will call the case of the state of Michigan versus Armani Williams, 25S 4536572?
Tiffany Woods for the people.
Good morning, Ashley Moulton on behalf of Ms. Williams. State your name, please.
Ms. Armani Williams, please unmute your device, state your name.
Armani Williams.
And turn on your camera for me, please, ma'am.
I'm sorry.
Miss Williams is valid.
Yes.
Congratulations.
Oh, thank you.
And Your Honor, her license actually was always valid. Her purse got stolen.
Yeah, it was I think it was like around the time of my birthday, and I think I can't remember the exact ticket date, but I think it was around the time my purse got stolen, and that's why I didn't physically have it. But I was always valid.
Oh. Yeah, I saw that.
Yep, and I got pulled over on my way home from work. I work 8 to 4:30. Sometimes I get off at 7 a.m. Kind of my situation today, yeah.
All right. Ms. Woods, where are you with this, given that?
Judge, I don't see it on my docket. Is it just not having a license? Is that what the charge is?
Without a license.
It just wasn't physically not on my person.
Oh, Judge, I dismiss it since we have confirmation that she is a valid driver.
All right, case is dismissed.
I appreciate that.
You're all set, ma'am.
Welcome.
All right, thank you.
You're welcome.
Guys, bye-bye.
What will call case of the state of Michigan versus Ronald Yell, case number 25L00301.
Tiffany Woods for the people.
Ashley Moulton on behalf of Mr. Yale. State your name, sir.
Ronald Yo.
Thank you. Good morning, Mr. Yell.
Good morning, Your Honor.
All right, we're here for a pretrial today.
Yes, Your Honor. We just received an offer this morning. Mr. Yale would like to discuss it a little further, continue plea negotiations. So if we could get a brief adjournment.
Either October 23rd or October 30th. What is the preference?
Does October 23rd work for you, Mr. Yale?
He's looking
Yes, it
up.
does.
All right.
Okay.
Yeah, I was looking at my calendar.
October 23rd, 2025 at 9:00 a.m. Bond will continue. We'll see you then, sir. Okay.
Thank you, Your Honor.
Thank you. Have a good day, sir.
You too.
Bye-bye.
Bye now.
Apartments.com gives landlords the tools to manage your rentals with ease. It's like having a whole team of you.
What will call the case of the state of Michigan versus Rodell Phelan, case number 25F00267.
Tiffany Woods for the people.
Allison Muller here on behalf of Rodell Phelan. Mr. Phelan, can you unmute and state your name?
Yes, Rodell Phelan.
Thank you. Good morning. We're here for an adjourned pretrial.
Yes, Your Honor, there is an offer from the state that we'd like to move forward with today. Ms. Woods, my understanding of the offer is that Mr. Phelan would be pleading to an added count of trespass and no upfront jail, referral to probation, and he's responsible for any restitution.
That is correct.
Thank you. I'm just writing it up.
And it would be an added count to judge with count 1 dismissed.
Thank you. All right, sir, it's my understanding you're gonna be pleading guilty to an added count 2 of restitution. That is still a misdemeanor, but it carries a maximum. Nope, I said that wrong. Added count 2 of trespass. It is still a misdemeanor, but it carries a maximum penalty of
Your name. Not your, they just said it.
carries a maximum penalty of 30 days and a $250 fine plus court costs. And then count 1, the more serious offense of larceny, 200 to 1,000 would be dismissed. You also have a referral to probation and need to pay up restitution, and there's no upfront. Is that your understanding of the agreement?
Yes.
Please raise your, and that's what you want to do?
Yeah.
Please raise your right hand to be sworn. Is there a talking in the background? I need to not have that going on right now, please.
Yes, I hear you.
Did you hear me about the child? You need to move away from the child.
All right, I hear you.
All right, thank you. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over some rights that you have that you're going to give up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Yes.
You have the right to have a trial by a judge or a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
You understand you're giving up all those rights and you're not going to be having a trial of any sort?
Yes.
You also understand that there's no automatic right to appeal this decision. So the decision you're making today, in all likelihood, is going to stick with you.
Yes.
And also, if you were on probation, parole, or bond when this offense occurred on April 18th of 2024, you could be in violation of that probation, parole, or bond. Were you on those on that date?
Oh, yes, I was.
And do you understand that? Are you still on it?
Oh, no, I ain't.
Okay, all right, good. And if you're not a U.S. citizen, you could have immigration consequences.
Yes.
All right. To the charge of trespass, how do you plead?
I plead guilty.
Anyone promise you anything other than what we just put on the record?
No.
Anyone threaten you in any way, shape, or form?
No.
All right. On or about April 18th of 2024, were you at the vicinity of 2737 Woodruff Lane here in Ypsilanti Township?
Yes.
And while you were there, were you told not to be on the premises and you came back on the premises?
Yes.
I find that there's a factual basis for the plea that has been willingly and knowingly made. Are you satisfied, Ms. Mullen?
Yes, Your Honor.
That's fine. Ms. Woods?
Yes, Judge.
All right. Sentencing in this matter will be on October 30th, 2025 at 10 o'clock a.m.
Excuse me.
Yes, Mr. Phelan.
Do I got to call the probation? Do I got to call the probation?
You do have to call the probation, Mr. Phelan. Did you write down the phone number when I gave you?
I think he left me the number. He texted me the number.
Okay, call that number, okay?
All right, thank you.
Thank you. You're welcome. Count 1 is dismissed. I'll see you back here on October 30th at 10 o'clock a.m. Please call them tomorrow after 9 o'clock to talk to probation, okay?
All right, thank you.
Your bond is continued. You're welcome. Have a good day, sir.
All right.
Bye.
Yep, I'm done. They said.
All right, the court will call the case of the state of Michigan versus Daquan Taylor, 25S00302.
Tiffany Woods for the people.
Ms. Moulton is in the breakout room right now.
Sorry, Your Honor. Allison Muller here on behalf of Mr. Taylor. Mr. Taylor, can you state your name?
Mr. DeQuan Taylor, please unmute your device, state your name. Turn on your camera.
DeQuan Taylor.
Please turn on your camera. Sir, you need to be in front of the camera so I can see your face. Ms. Muller?
I'm not sure if he's frozen, Your Honor.
He's not frozen. He keeps moving the camera around, but he's not coming in front of it.
Okay, Mr. Taylor, can you please appear in front of the camera with your face visible?
Turn the camera around, you idiot.
Mr. Taylor, is probably gonna need to come in person the next time to get this cleared. Where are we with this case?
Your Honor, we are requesting an adjournment. We did receive the offer this morning and we'd like a little more time to discuss the offer and how to move forward with Mr. Taylor.
November 6th, 2025 at 9 a.m. in Purple
Thank you.
What we recall a case of the state of Michigan versus Kiera Rolex, case number 25S00366.
Tiffany Woods for the people.
Allison Muller here on behalf of Ms. Rolex. Ms. Rolex, can you unmute and state your name again, please?
Yeah, Rolex.
Thank you. All right. Where are we with this? You had a chance to talk to Ms. Rolex about what she wanted to do?
I did. Thank you for passing it. We went over the offer and the fact that setting it means that Ms. Rolex will be rejecting that offer and it won't come up again. She understands and does request to set this matter for final settlement conference.
Final settlement conference will be October 31st, 2025 at 9:30 a.m. Jury selection will be on November 7th, 2025 at 8:30 a.m. The October 31st one, ma'am, is still on Zoom. But the jury selection, when we have a jury present, is here in person, okay?
Yes.
All right, your bond is continued and you're all set, ma'am. Have a good day.
You too.
Thank you. You ready to recall the Tanya Hall matter?
Yes, Your Honor.
Your court call the case of the state of Michigan versus Tanya Hall, 21 FB 1472.
Tiffany Woods for the people.
Morning, Your Honor. Robert J. Pill on behalf of Ms. Hall. Tanya, would you state your name for the record?
Tanya Hall.
Thank you.
Judge, this is my understanding of it after speaking with Tanya. Again, she's been residing on and off at the Delana Center, but this is my understanding of what happened.
Mr. Kilowog,
Yes.
I'm not asking you about what happened yet. So one moment, please.
Okay.
Mr. Pappin again?
Good morning, Your Honor.
Good morning.
She has not tested with community corrections since that positive test.
Thank you. All right, Mr. Kilowall, I don't operate like that. I don't want to have an explanation of what happened yet. She was supposed to be testing and she hasn't been testing. So, unless the court says she doesn't need to test anymore, there needs to be testing or some communication with the prosecutor's office. So she is in violation of her bond. So does she want to have a hearing on that violation, or does she want to admit to the bond violation?
Judge, she would admit that she missed testing, but she didn't. If I can just briefly explain, Judge, just very quickly.
Mr. Kilowall, she'll be able to give an explanation afterwards.
Yes. Well, Judge, I guess we have to have a hearing on the matter. She wasn't aware she needed to be testing.
Oh, okay, we can have a hearing. When would you like to do that?
Well, do you have any dates, Judge?
Ms. Woods, how long do you need to get someone from community corrections here to indicate when she's supposed to, whether or not she was testing? Because if the explanation is she didn't know she was supposed to be testing, she was ordered to test by this court. So I'm not sure what the hearing is about, but we can have one. I don't think she's gonna like the result.
Judge, if you gave me 2 minutes, she was
not going to do that. I just explained to you the process here. The process is simple. If she wants to admit to it, you can give me an explanation afterwards.
Yes,
If
Judge.
you don't want to do that, then you can go your route.
She will admit to missing the testing.
Thank you. All right, Miss Tanya Hall.
Yes.
Ma'am, it's my understanding that you're going to acknowledge that you have not been testing as ordered by the court. Is that correct?
Yes.
All right, please raise your right hand to be sworn.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without having to go to court or pay expensive upfront legal fees. Listen, if you've been in a car accident in the past year, even as a passenger, you could be owed a significant cash pay.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Is it true that you have been missing testing ever since June 12th of 2025?
Yeah.
And is it also true that you tested positive for cocaine on June 12th of 2025?
Yes.
Thank you. I find that there's a knowing and willing admission to the violation of the bond. Are you satisfied, Ms. Woods?
Yes, Judge.
Mr. Kilowall?
Yes, Your Honor.
Right, now, what is the explanation?
Judge, just very briefly, she entered into the hospital, U of M, on stomach issues on June 30th. She was in there and they recommended that she go into some type of treatment. Obviously, she has a history of substance abuse. She went into Sacred Heart treatment July 8th through July 29th. Their recommendation was that you get into a support group. Since that time of July 29th, she has been going to AANA every day unless her health warrants or she can't. But she does it at least twice a week. She's going to acknowledge she should have known she should have been testing, but if she were to test today, she would be clean. With the help of the Delana Center, she's really turned her life around. It's no disrespect to the court that she missed the testing, but she has turned her life around and she is clean and sober, and she wants the court to know that. And she continues to be in a support group.
We'll see whether she's clean or sober, because she's gonna need to test within 24 hours.
That's fine.
As far as the sentencing is concerned, have you reviewed the report with your client?
I have, Your Honor.
And any corrections, additions, or deletions to that?
Judge, on the face sheet, the sentencing date says it was yesterday. It should be today's date, 10/2. It also lists Attorney Simpson as her attorney. It should be myself, Mr. Kilowald. Other than that, I've gone over the report with my client, including the mistesting. We've gone over the recommendation. It's appropriate. My client will continue testing. and be in a support group. And I would just ask if there could be some consideration regarding the fines and costs that she is indigent.
Judge, I've also had an opportunity to review the PSIR recommendation, and I would ask the court to follow the recommendation. In regards to fines and costs with the court, Judge, I would leave that within your discretion. Thank you.
Thank you. All right, I'll make the correction to the face of the report with respect to the sentencing date, and it will reflect a new, the attorney should be, get that wrong. The attorney should be Mr. Robert J. Killwall on there. That will be changed. And then, ma'am, is there something that you wanted to say prior to sentencing?
No, ma'am.
All right. I am going to follow the recommendation of the probation department. It is the sentence of this court that you serve 365 days in the Washington County Jail, credit for 1 day served, 364 is suspended. What that means, ma'am, is you don't have to do any additional jail time unless you violate some of the orders of the court, okay?
Yes, ma'am.
You are on probation for 24 months and you'll be eligible for early discharge once you complete half of that if you've complied with all the terms of the sentencing, okay?
Mm-hmm.
The fines and court costs in this particular case, I'm gonna set those. Are you working at all yet, ma'am, or no?
No, ma'am.
Mhm. I'm gonna set those at $225. $30 per month probation oversight fee. So if you complete everything in that first year, then you won't have to pay the second year. Are you listening, ma'am?
Yes, ma'am, I'm listening.
If you complete all of the terms in the first year, you won't have to pay the rest of that probation oversight fee, okay?
All right.
You're to report to the probation officer monthly via the online reporting platform and report during the second week of each month. You're to meet with probation when and where directed, including any and all home visits. You're to complete an outpatient assessment unless do you have one done recently, Ms. Hall?
Yes, I just got out of treatment.
So when was the last assessment done?
The July
sometime in July?
I think it was in July.
So this is
July.
Imagine bringing your side project to life just by thinking about it. Meet Base 44.
This is what I'm gonna do is I'm gonna have you sign a release of information. What treatment were you in?
Sacred Heart.
So sign a release of information with Sacred Heart so that they can see what your status is, okay?
All right.
And probation nation will decide whether you need another assessment. No use or possession of alcohol, marijuana, illegal drugs, paraphernalia, and no being in the presence of anyone using or having any of those, along with firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using those. You must drug and alcohol test 1 time per week, and any other times is ordered by probation police or any other provider. You must test within 24 hours, ma'am, okay?
Yes, ma'am.
You to attend NA meetings 3 times per week and obtain a sponsor within 45 days and provide proof of that and your meeting to your probation agent. We're gonna have a review with me on January 8th, 2026. Nope, I don't wanna do that. That's too far out. We're gonna have a review in this case. Hey, Matt, do you have, can we look at a date like mid-December?
Yeah.
A Thursday. Yeah. And good morning, by the way. That's good. December 11th, 2025 at 10 o'clock a.m. will be your next review, okay?
Yes, ma'am.
So, ma'am, please make sure you test within 24 hours. If you don't, a bench warrant is going to issue for your arrest, okay?
Do I have to pay for it?
You do.
I don't have any money.
Ma'am, you need to test within 24 hours. So you need to figure that out.
Tanya,
I'm on
Tanya,
I'm
we'll
on the
work it
SAT
out.
income.
Tanya, we'll work it out.
All right.
Judge, can she have a payment plan on 225 fines and costs?
Yeah, they'll set that up for her over the course of the 2 years or 1 year or whatever time she wants. They set it up for probation.
Thank you for
You're
your
welcome.
consideration.
Thank you. Have a good day.
Tanya,
Thanks.
give me a call. Give me a call. Thank you, Judge.
All right.
Thank you. Court will call the case of the state of Michigan versus Donovan Lawrence, case number 25S00333.
Tiffany Woods for the people.
Tanya, we're done.
Donovan Lawrence.
Thank you. All right, could someone step in for Mr. Donovan Lawrence today, please, from the PD's office?
Yes, Your Honor. This is Matthew Mansour on behalf of Mr. Lawrence.
We're here for a pretrial.
Yes, we are, Your Honor. We're going to be requesting an adjournment. We have an offer. We just want a little bit of time to go over that offer with Mr. Lawrence.
Pretrial in this matter will be adjourned to October 23rd, 2025 at 9:00 a.m. Mr. Lawrence, we'll see you then, okay?
Thank you.
Thank you. Have a good day.
Thank you.
Before we call the case of the state of Michigan versus Quran Lemaster, case number 25FB0152.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Lemaster. Mr. Lemaster, can you please unmute and state your name?
Is Quran Lemaster?
Thank you.
Yes.
We're here for sentencing today. Have you had a chance to review the report with your client?
Your Honor, this is Ms. Moulton's client. I know she's in a breakout room. I'm messaging her to see if she went over the report with Mr. Lemaster. But Lemaster, do you remember going over the report with Ms. Moulton?
Yes.
Okay. Your Honor, if you want, if we could pass it just till she comes back.
I will pass it.
Thank you.
Is it gonna be long? I'm not rushing or anything, but my phone's on 60%. I'm on the roof working. I would have to go down and put my phone on the charger. It's not working.
Mr. Lemaster, I can't tell you how long it's gonna be. She's in a breakout room. I'll call it once she lets the recorder know she's ready, okay?
Yes, ma'am. Thank you.
The court will call the case of the state of Michigan versus Stevie Smith, case number 25S00234.
Tiffany Woods for the people.
Matthew Mansour on behalf of Miss Smith. Miss Smith, can you please unmute, put your camera on, and state your name for the court?
Stevie Smith, please unmute your device, turn on your camera, and state your name.
Hello, I'm sorry. Hello,
Please state your name.
Stevie Smith.
Thank you. We're here for a pretrial today.
Yes, Your Honor, that's correct. We had an old, outdated number for Miss Smith, so I did not have any contact with her prior to today. I met with her in a breakout room. I have an updated phone number, so we're going to be good on that end, and I'm going to refer her to get an assessment. So if we could just request an adjournment for those reasons.
Pretrials adjourned on November 6, 2025 at 9:00 a.m. Bond is continued. We'll see you then, Ms. Smith, okay?
Thank you. I'll see you then.
Have a good day.
You as well.
Thank you.
My name is Tori Hinton. I am a certified child life specialist here at St. Jude.
The court will recall the matter of the state of Michigan versus Shannon Remsen, case number 24FB1337 for the third time.
Tiffany Woods for the people.
Mr. Rucker. Is Shannon Remsen present?
Yes, I am, Your Honor.
Mr. Remsen, you should contact your attorney because I'm not going to keep recalling this case.
Your Honor, I've called him several times. He's checked in. I've seen him check in, and he's been checking in and checking out. I'm calling him right now.
I'm passing it. I only recalled it for your purposes because I don't think it's fair for you to continue to have to sit here. But when I called it the first time, he wasn't here, and then he put someone on the screen that's not him. We don't know who he is. I call it again. He's not here. Now, this is the third time. It is not your fault, but I'm annoyed.
I understand.
All right, I will recall it once he checks in and literally tells the reporter.
No, I'm on. She's not hearing me. I'm answering her.
He's saying he's on.
He hasn't unmuted.
Unmute.
Turn on your screen, like one of those or both of those things.
It's not that. I don't know what's going on. I've been trying to.
Push the unmute button that I just sent you, Mr. Rucker.
Your Honor?
Yes.
It's like, okay, I think this will do it.
There you go. Please state your name, Counselor.
Tyron Rucker on behalf of Mr. Shannon Remsen.
Thank you so much. All right, we're here for a pretrial today.
Your Honor, we are.
Where are we with this pretrial, please?
Judge, I have a plea offer. The plea offer would be to plead to the assault and battery. I would agree a sentencing agreement to no upfront jail, a referral to probation, and restitution would be reserved.
Do you need to speak with your client, Mr. Rucker?
I don't believe so, Your Honor.
Okay, what would you like to do, sir?
We're setting this for a jury trial.
Final settlement conference in this case will be in October 31st. At 9:30 a.m.
At what time, Your Honor?
9:30 a.m. It's on Zoom again.
And then I just want to place on the record that once it gets set for a final settlement conference, there will be no further plea offers.
Mr. Rucker, do you still want to move forward, or you need to speak with your client briefly? We can put you in a breakout room. What do you want to do? I'm going to give you that date and your jury selection date, which is going to be November 7th, if you want to continue to move forward.
I believe we can move forward, Your Honor.
All right. Mr. Remsen, you don't want to talk to your attorney, given that no further offers will be made, or do you want to speak with your counsel?
No, I'm fine, Your Honor. Go on forward.
November 7th, 2025 at 8:30 a.m. for jury selection. That one is in person.
Okay, what date was that again, Your Honor?
The first one is October 31st at 9:30. That one's on Zoom. The second one is November 7th at 8:30 a.m. for jury selection. That's
all right. Thank you.
Okay.
Thank you.
Bond is continued, and we'll see you all on October 31st. Have a good day.
Thank you. Have a good day.
Good day.
We'll call the case of the state of Michigan versus Harold Dennis, case number 25 FB 1068.
Tiffany Woods for the people.
Allison Muller here on behalf of Harold Dennis. Mr. Dennis, can you state your name?
I sent you an unmute button, sir. Can you push that button? And there you go. Please state your name.
Did you hear me?
Just say it again, please.
Harold Dennis.
Thank you so much. All right. We're here today for a review. It looks like Mr. Dennis needs to enroll in the Class A program.
Yes, February 5th and February 12th.
I'm sorry, what now?
I mean, I'm sorry, not February. October 5th, October 12th.
Okay, thank you.
I'm sorry.
That's okay. And you need to check in with your probation agent monthly. Apparently you haven't been doing that.
Yes, I thought primarily it was the class as well as paying probation, but obviously if I'm on probation, I do need to check in. So,
All right. And it looks like you've been making your payments and
yes.
Yeah, those are the only things you need to do. You need to check in within 24 hours and he won't file a violation. You got the class all lined up and continue with the rest of your terms. And then I'll see you back here in 90 days. Is there anything you wanted to say?
I want to say this has been, frankly speaking, a good situation for me, and I've been getting my life together as far as business as well. I'm getting swamped. So as cavalier as you said that I sounded, actually it's worked out pretty well.
I'm very glad to see that. I'm very glad you're doing what you're supposed to be doing. And I truly believe that the lack of reporting was simply a misunderstanding and you're going to do what you need to do.
What if you were prepared for all those interview curveballs?
This was an unusual situation. So I'm glad that it's working out for you and your business, sir. Okay.
Thank you.
Keep up the good work and I'll see you back in 90 days on January 8th, 2026. And then let's see, what did we do here? A total of 6 months. That was in July. You'll be eligible for discharge. Well, actually, once he completes that class, after that, he'll be eligible for discharge once he's paid off his fines and costs. And if he's paid them all off, I have no problem with discharging him early once all that stuff is done. Okay?
So I can prepare to go to Italy?
You can prepare as long as you've done that class to be done with this. Okay?
Okay.
All right. What I'll do is, you think you'll be done paying by November? Let me see, what do you have? Do we have restitution?
What's the balance?
I'm looking here, $355.
Yes.
You think you'll be done with that by November the 13th?
Yes.
All right, we'll put it on for then so you can be discharged. How about that?
That sounds great.
Anything from I should ask the prosecutor. She may object. Anything from the prosecution on this?
No, Judge.
All right, good. Yeah, I will. All right, so I will see you back here, sir, on November the 13th, 2025 at 10 o'clock a.m.
I'm sorry, what day is that on?
November 13th?
Yes. What day is that?
Oh, what day? I'm sorry. It'll be a Thursday. It's just like today.
Okay, great. Okay. I'll be here.
Yeah. And I'll say this, if your class is completed and you have paid everything off, probation can discharge you early, okay? Discharge you after that's done, so you don't have to show up, but you'll have to check with them.
Okay, I definitely will check.
So this may be our last time seeing each other, sir, so take care of yourself.
Well, I'll see you on November, Wanda.
On the river?
November.
Oh, in November. I
13th.
said, if you are, I was like, on the river, what is happening at the river? What I'm saying to you is, I'm saying that if you are done with everything, they can discharge you without you having to show up. So if they do discharge you without having to show up, then I won't see you in November.
Oh, I see. Well, thank you, Ms. Buck. And I would say I am not cavalier about this. It has been, frankly speaking, a good experience and learning experience as well.
Good. Take care, Mr. Dance.
Thank you.
Thank you. All right, the daughter has a preliminary examination in her new case on October 7th. Is that correct?
Yes, ma'am. That's correct.
What's taking so long?
I don't know. They just keep adjourning it in the beginning, but it should be being handled now. Oh, yeah, already.
And she's here on a bond violation for the new case? Or
Yes, well, this is the case, Your Honor, that's a little complicated because she was sentenced into our recovery court. So we're waiting to see basically what's happening with the new charges.
gotcha. So we can't do anything until we know about that, because if she has a new felony, we can't take her.
Correct, yes.
All right. I can put a note on my file for that. So do we want to go to October? So it is the actual exam, is that what it is?
Yes, they'll be holding the exams on the 9th, Your Honor.
What is the charge again?
Your Honor, one is just a moment. Your Honor, one case is a uttering and publishing count, and the other is a fleeing 4th degree.
I know where you at. These people, they are trying to fetch you, but they said.
All right. I'll put this over to October the, I think the 9th is better than the 16th, to be honest. Correct. I'll put it over to October the 9th to see if they get carried on to pre-trials, okay? October 9th, 2025 at 10 a.m. Bond is continued at denied. We'll see you all then.
Thank you.
Thank you. We'll call the case of State of Michigan versus Kier Adams, case number 25-00170.
Tiffany Woods for the people.
Ashley Moten on behalf of Ms. Adams. State your name, ma'am.
Kier Adams.
Thank you. We're here for pretrial, adjourned pretrial today.
Yes, the offer today is to plead to OWI first. And Ms. Adams would like to accept that offer. A referral to probation, no jail time.
That is not totally correct. I told defense counsel it'd be no jail if she had no violations from here until sentencing. So I just want to make sure that that's clear and on the record.
All right, let me write all this up.
Ms. Adams, are you still want to accept that offer?
Yes.
So you all will have to correct me if I got some portion of it wrong. I'm writing it down as fervently as I can. So my understanding is that she's going to be pleading guilty to an added count 2 of operating while intoxicated first offense, and count 1, the second offense. Notice.
Holiday Max was like, I was astounded, genuinely. It exceeded my expectations. It really did. I first found
Piece would be dismissed, and there would be no upfront jail if there are no further violations of bond. and there will be a referral to the probation department. Did I miss anything else?
No, Judge, that is correct.
All right. Is that your understanding of the agreement, Ms. Adams?
Yes.
And that's what you want to do?
Yes.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over some rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again. Okay?
Okay.
You have the right to have a trial by a judge or a jury, at which time you can call witnesses to speak for you. You get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you can choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. You understand those rights?
Yes.
You understand you're giving them all up. You're not going to be having a trial of any sort.
Yes.
And you also understand that there's no automatic right for you to appeal the choice you're making today. So in all likelihood, this choice is going to stick with you.
Yes.
If you're on probation, parole, or bond, then you could be in violation of that probation, parole, or bond if you were on it on November 20th, 24, and you still are. Are you, and were you on one back then?
Yes.
All right. And you've had a chance to talk about the potential repercussions of, and if you are not a U.S. citizen, you could have immigration consequences. You understand that part?
Yes.
Right. To the charge of operating while intoxicated, which is a misdemeanor carrying a maximum penalty of up to 93 days in the Washington County Jail and/or a $500 fine plus court costs. How do you plead?
Guilty.
Anyone promise you anything other than what we just put on the record to get you to plead guilty?
No.
Anyone threatening you in any way, shape, or form?
No.
All right. On November 20th, 2024, were you operating a motor vehicle at the vicinity of westbound I-94 and South Huron Street?
Yes.
And at the time, were you under the influence of alcohol, ma'am?
Yes.
What was the BAC, and do the parties stipulate to it?
Judge, the BAC in this case is 0.289.
Thank you. Ms. Moulton, do you stipulate to that?
Yes.
All right. Is this the case where she was driving the wrong way on the freeway?
That is correct, Judge.
Thank you. Find that there's a knowing and willing plea to the charge. Are you satisfied, Ms. Woods?
Yes, Judge.
Ms. Moulton?
Yes, I am.
Thank you. Sentencing in this case will be on November the 6th, 2025 at 10 o'clock a.m. Ma'am, were you on the call earlier when I gave out the phone number for the probation department?
I think I missed it.
All right. Everybody on the call that didn't write it down, please write it down at this time. You ready?
Yes.
734 483 7336. Please call them tomorrow after 9 o'clock. They'll schedule a time for you to have your pre-sentence investigation report done. You also will need to have an alcohol assessment done if you don't have one of those already.
I did do that.
All right. Please, Ms. Moulton, make sure that the probation department has a copy of that alcohol assessment.
Okay, I will send it. May I address bonds, Will?
What part of bond are you trying to address?
The sober link.
Okay, thank you. You may proceed.
Ms. Adams has been testing with the sober link since June 17th. There were, I believe, 3 late tests, but she hasn't had any positive tests. We're requesting if that could be, that condition could be removed. She is being tested here and with her other case that she's on probation for.
Judge, I'd be against that request considering her BAC in the case, this case is so high, 0.289. She has an OWI from August of 2024. Her behavior of driving down the wrong way, I believe that if anything, she needs to stay on SoberLink. Plus my initial jail lies on the fact whether she's going to have any bond violations, I would like that to remain in place. So when it comes to sentencing, we can find out if she's not getting any initial jail. Thank you.
Thank you. I agree with the.
Excuse me? How do you read so many books?
I don't. I listen.
What do you mean you listen?
I use this app.
I'm not removing that. She'll remain on SoberLink. So the record is clear that motion is denied. We'll call the case of the state of Michigan versus William Vincent, case number 25S00180.
Tiffany Woods for the people.
Ashley Moten on behalf of Mr. Vincent. State your name, sir.
Unmute, moron.
Me?
William Vincent. Did the attorney the master coming in?
I have,
Is that Ms.
that's my
Moten?
case as well. Yes.
Okay. All right, thank you. Mr. Vincent, please state your name, sir. Oh, you need to come closer to the camera or something. We can barely hear you, sir.
Hold on.
Okay, there we go. Right where you were. Stay right there.
Can you hear me now?
Yes. Please state it again.
Good morning, Judge.
Good morning. Please state your name again.
William Vincent.
Thank you. Perfect. All right, we're here for a pretrial.
I can't hear you.
Honor.
We're here for a pretrial.
Upfront jail if he has no bond violations at the time of sentencing. Thank you.
And if I may also address the SoberLink in this case.
I can tell you now that if he's over 0.15 with a BAC, I'm not removing the SoberLink.
Okay.
Thank you. Sir, it's my understanding that you're going to be pleading guilty to an added count 2 of operating while intoxicated, which is misdemeanor carrying a maximum penalty of up to 93 days and or $500 fine plus court costs. Count 1, the more serious offense of 0.17 is going to be dismissed. There will be a referral to probation with an agreement that there will be no upfront jail if you don't have any bond violations in the interim time between now and sentencing. Is that your understanding of the agreement?
Yes, Your Honor. I have a question. The last time I was in your courtroom, they was trying to violate me for saying I didn't have the SoberLink, and this got carried on until this court date. And I feel like I've been more than compliant with everything. It's not I don't have a problem with the SoberLink. It's just that I'm being charged, and I really don't have that type of finance. I'm just really getting back to work. As you can see right now, I'm at work, literally. And I'm trying to get it to where it's something where I don't want to be in debt or be in violation for not being able to pay, for this SoberLink. And I feel like I've been more than compliant. I haven't dropped any, I haven't blew any dirties. I realized.
Please stop talking. Please stop talking. Sir, you don't decide when you get off the SoberLink. I do. I understand your concerns regarding costs, but that is not my first concern. My first concern is protection of the community, and I've answered no to you getting off SoberLink, and my answer remains the same. Do you have any questions about that, or you want to speak with your attorney?
I like to speak with my attorney.
Certainly. Yeah, I'm going to do this other case first. I'm going to do Mr. LeMaster's case, and then you can go in and speak with your client. The court will call the case of the state of Michigan versus Erane Washington, 25 FB 0152.
Tiffany Woods for the people.
Ashley Moten on behalf of Mr. LeMaster. State your name, sir. Sorry, Judge, he's at work, I believe.
I know.
So, Alabaster,
Thank you. All right. We have person testimony today.
I'm sorry, say it
Yes.
again. Oh,
I did go over the pre-sentence investigation report with Mr. Lemaster. Only two things. I have one question and one comment. One of the conditions is no use of marijuana. He did provide a medical marijuana card with the expiration date of July of 20.
Stop buying generic Viagra if you're over 60. You qualify for 9 tablets of 100 milligram generic.
27.
And I don't believe that he filed a letter of necessity or was given court permission to be able to use marijuana. And this is a CS case, so I have concerns with that.
Well, he does need to file his letter of necessity, but I don't think it being a CS case, unless we can show that he violated the MMA Act and was using marijuana at the same time. It's simply being a CS case or a controlled substance case doesn't mean that he's ineligible. So the first piece, though, is he needs to file the letter of necessity.
Okay. And it's also mentioned in assessment with Don Farms. He did one with Matt Statman. Is this something in additional that he needs to do?
It's a different type of an assessment, correct?
Okay. Just make sure for clarity. Thank you.
I think that's a free assessment. It's not a cost. I don't think there's a cost.
Okay. Otherwise, no changes.
All right, thank you. Unless is he in Don Farms or anything like that at this time?
No.
Thank you.
Judge, I've also had an opportunity to review the PSIR. I would ask the court to follow the recommendations within that report. Thank you.
Thank you, sir. Is there anything you'd like to say today?
yes. So a question about the assessment or what I was about the medical marijuana card. What do I have to present?
Your attorney will explain it to you. Sir, you need to have a letter of necessity from your doctor saying why you have to use marijuana and what's the purpose of it. I review that and determine whether I think it's sufficient or not.
Okay, because I had sent one to my probation officer. She should have it on file, but I also have it on file. I can email it to her right now if need be.
Well, you're talking about community corrections. That's not your probation officer.
Okay.
Your probation officer is Mr. Pappenhagen. You need to send it to him.
Okay, sir. Gotcha.
All right. Anything else you want to say with respect to the sentencing, sir?
I guess thank you for your time, and I will talk to my attorney about the things that I need to do.
All right. Thank you, sir.
Of course.
This case, is certainly interesting, an interesting read. I'm going to follow the recommendation. It is a sentence of the court that you serve 365 days in the Washington County Jail for 1 day served. The balance of that time is suspended, so you won't have to do any jail time as long as you complete all the terms of your probation. You must do 5 days for a total of 40 hours of community service. You're on probation for 12 months. What that means for you, sir, is that if you complete everything that I'm ordering you to do in the first 6 months, you can be discharged after 6 months, but you got to complete it all and have all your fines and costs paid off, okay?
Okay. Is she gonna tell me like my fines and costs, or will you be?
Getting ready to do all of that right now.
Oh, sorry.
Okay, that's okay. Fines and court costs in this case for a total of $425. Probation oversight fee of $30. That oversight fee can be waived for the end of the 6 months if you paid off the rest of it. So you don't have to pay it, but for months that you're actually on probation. So if you get discharged halfway through, you don't have to pay it for the remainder of that year, okay? You to report to the probation officer monthly via the online reporting platform. So you need to report during the second week of each month and meet with probation when and where directed, including any and all home visits. You to complete an outpatient assessment with Don Farm within 14 days and follow any recommendations that they have. And you need to sign a release of information. You need to complete Trying to figure out, does he need to do the Mad Victim Impact Panel? Mr. Pappenhagen, I don't think this was a driving one. Or is there a specific reason? Is there a specific reason you're requesting that?
Get you set up for.
My apologies, Your Honor. He does not need.
Okay, all right. No use or possession of firearm components, ammunition, or other dangerous weapons, no alcohol, marijuana, illegal drugs, drug paraphernalia, and no being in the presence of anyone using those. You must drug and alcohol test 3 times per month, and any other times is ordered by the court, probation, or police. And you are to attend a total of 15 open NA meetings.
Great bar.
And we'll have a review in 90 days on January the 8th of 2027. And that's going to be, I'm sorry, I didn't put you out 2 years already, 2026. And that'll be at 10 o'clock a.m., sir.
Can you said 2026 when?
January the 8th.
January 8th, 2026. Gotcha.
But you need to contact the probation department tomorrow after 9 o'clock so they can go over this whole contract with you. Okay?
Yes, ma'am. Is my probation officer on video? Did he just, was that Mr.
That was him. That was him that I asked about a part of the recommendation. That's Mr. Pappenhagen, correct?
Gotcha. So I gotta get his number so I can get in touch with him.
Did you write down the phone number that I handed out earlier today, sir?
No, I'm sorry. No, I wasn't able to. I didn't have a pencil at the time. Somebody just stole my pencil. Hey, where?
Y'all be coming up with some stuff, I tell you.
Hey, where'd that pencil go?
My goodness.
It's all right. I just need to write this number down. Sorry.
You ready?
Yes, ma'am.
734.
734.
Somebody was doing something over here.
Oh,
and the one time I shot.
Hello?
483.
483.
73. 36.
73. 36. 734 483 7336.
Yes, call them tomorrow after 9 o'clock a.m., okay?
Yes, ma'am.
Thank you. Have a good day.
Thank you. You as well. You guys have a blessed one.
Thank you. The court will call the case. The court will call the case of the state of Michigan versus Xavier Bell, case number 25S00083.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Xavier Bell. Xavier, can you unmute and say your name?
Xavier Bell.
Thank you. All right, we're here for a review today.
Yes, we are, Your Honor. And I went over the report with Mr. Bell. We are asking to follow the recommendation, but we have some news for the court. Since he was on probation out of Mount Clemens while he picked up this charge, the judge out there in Mount Clemens ordered Mr. Bell to turn himself in tomorrow for 30 days for pleading to this charge. He plans to do that. That's what he's going to do this week, tomorrow, hopefully. So we're asking this honorable court to set the review for 90 days instead of the 60 days that was in the recommendation. So he can get his conditions done after he's released.
Okay. Mr. Bell, is that correct? You're going to turn yourself in tomorrow?
Yes, ma'am.
Mm-hmm. Is there anything, well, before I go to you, Ms. Woods, anything you want to say?
No, Judge, I would leave it to the court's discretion. Thank you.
Thank you. Anything you want to say, Mr. Bell, before I sentence you?
No, ma'am.
All right. Well, sir, you still need to complete the ABR Highway Safety Program within, I'm going to make that 60 days. Okay? So it'll give you 30 days after you do your probation violation. complete the MADVAC victim impact within 60 days also, and provide proof of your AA meetings prior to your next court date. I'm going to set that court date out 90 days as your probation agent has indicated. Your attorney has indicated to January 8th, 2026 at 10 o'clock a.m.
Thank you, Your Honor. We're going to get those conditions done. We're going to come back on January 8th and see where we're at.
Which county did you say that was in?
I don't know what county Mount Clemens is in.
Okay. That's fine. That's all I need. All right. Thank you. Good luck to you, sir. Okay.
All right, thank you.
You're welcome.
Xavier, call me if you need me.
All right, bet.
Thanks.
Oh, it's McCall. Yeah, thank you. You're welcome. We'll call the case of the state of Michigan versus Joel Helm Mormon. Mr. Burgess.
Here, I tried to text.
You tried to text him, you said? All right. I'm gonna pass this. Tell your attorney to let the recorder know when he's ready. Please, sir. Mr. Mormon, let your attorney tell him to please send a message to the recorder. Court will call the case of the state of Michigan versus Hezekiah Mack Stewart, 20 FB 1712 14 17.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Mack Stewart. Mr. Mack Stewart, when you are unmuted, can you please say your name?
Hezekiah Mack Stewart.
Thank you. We're here for a probation violation today.
That is correct, Your Honor.
So apparently he has community corrections, bond violations, as well as a new charge. Out of this area for firearm receiving and concealing that occurred on September 23rd. What would you like to do today?
Your Honor, if we would be pleading guilty to the violations. You're asking, are we able to plead guilty to picking up the charge, or
not able to plead guilty to picking up a charge? Pleading guilty to picking up a charge is not a thing because people can be wrongfully accused. So he only pleads guilty to completing a new offense while he's on probation. So.
correct? Okay, so then we would be pleading guilty to picking up a new offense while on probation.
Nope, you can't. I just said you can't do that.
Okay.
Be guilty to being guilty of a new offense, but not acquiring a new charge. Anyone can acquire a charge, rightfully or wrongfully. So.
You got it, Your Honor. Then we would be requesting an adjournment to track that charge. He's set for preliminary examination on the 14th of October, so in a few weeks.
Ms. Woods, anything from you?
No, Judge, I'd leave it to the court's discretion.
Mm-hmm. I am. I'll put this over to October 23rd at 10 o'clock.
Thank you, Your Honor. Would you entertain bond or no?
I will not.
All right. Thought I'd ask.
Denied. Bond is continued at tonight.
Thank you, Your Honor. Mr. Mack Stewart, we're going to be back here on the 23rd.
Not only does he have the new charge, but he also hasn't completed the terms of his original probation either. So there's that.
Understood, Your Honor. Thank you.
Court will call the case of the state of Michigan versus Kendrick Curtis, 25S00179.
Tiffany Woods for the people.
Melissa Muller here on behalf of Kendrick Curtis. Mr. Curtis, can you state your name?
Kendrick Curtis.
Thank you. We're here for sentencing today.
Yes, Your Honor, we've had a chance to go over the sentencing report. We have no corrections, modifications, or deletions, and we do ask the court to follow the recommendation from probation.
Thank you. Ms. Woods? Ms. Woods, you're muted.
I'm sorry, Judge. Can we approach on this case with probation?
Of course.
Thank you.
Have your probation agent provide this court with what that term is so that you're not having to duplicate the same terms. Okay?
Okay, I have a question.
Yes, sir.
Like the adjournments of the court, is that gonna have something to do with my court fines and fees? Like, do that make me have to pay more?
No,
Okay.
that works. Yeah. Returning to court does not change your court fines and fees at all. Okay?
Okay.
Well, not your court fines and fees. It will affect the sober link because it could mean that he's on sober link for longer. Is sober link a condition of your felony probation also, sir, or no?
No, it's not.
Oh, okay. Well, it could increase that, but it also may mean that he's going to be on sober link here if there's nothing that addresses his our concerns regarding his OWI in the first place. So there's that. Yeah, I don't know if he's testing there or anything. Those are the things we need to find out. Okay.
Yeah, I'm testing there. I do random tests once a month.
Yeah. This one is a 0.198. So I'm not sure he's going to be random testing once a month. That's going to be another piece of it. So we'll need to know, sir, you may be ordered to be on SoberLink here anyway because of the level. And he just began testing in July. So I don't think it's really going to change much. Okay. So we'll see you back here on October 23rd, 2025 at 9 a.m. Okay?
All right, thank you.
You're welcome. Right, the court will recall the case of the state of Michigan versus Joel Helm Mormon, case number 20S00617.
Tiffany Woods for the people.
Good morning, Your Honor. Afternoon, I guess. May it please the Honorable Court, David Burgess on behalf of Joel Helm Mormon.
Good afternoon.
Apologize, Judge. I was on 2 Zooms. Sorry about that.
So. Yeah, I understand. Can you state your name again for us, Mr. Joel Helm?
Joel Helm.
Go ahead. Say it again, please.
Joel Helm Mormon.
Thank you. All right, we're here for pretrial. Mr. Burgess.
Your Honor, he has a pending case in front of Judge Hamoud at the circuit court. And I was trying to talk to the prosecutor and Mr. Ganatra regarding wrapping this case up with that. I don't know if Ms. Woods is aware of that. I just spoke with Mr. Ganatra a couple days ago about it. Okay, sorry, Tiffany.
Yes, I just wanted to let you know we are in contact about the global plea we plan on dismissing this case with an agreement with restitution. I know you do have a pretrial there on October 20th. So Judge, I'd ask for a pretrial after that date and see if he's entered into that plea offer, and then we'd be able to dismiss this case.
Does October 30th work with your calendar, Mr. Burgess?
Yes, Your Honor. What time, Judge? 9 o'clock?
9 o'clock.
Okay. All right.
October 30th at 9 a.m. Bond is continued.
Thank you, Your Honor.
Thank you. Have a good day.
You as well, Judge.
Bye-bye. You're all set, sir. Have a good day, Mr. Elmorman. We'll call the case of State of Michigan versus William Jane, case number 25S00155. I'm sorry, 115.
Tiffany, what's for the people?
Is Mr. William Jane present? If so, please unmute your device, state your name. You're not unmuted, so you have to unmute your device.
William Jane.
Thank you. All right, Mr. Pappenhagen turned on his camera. You may proceed, sir.
Good afternoon, Your Honor. He has completed his outpatient assessment and received that proof this morning.
Excellent. And based on the assessment, he was on a 9-month probationary term, which he got on in July. He wouldn't be eligible for discharge until November, but do you want me to still do 60 days, or where are we with respect to a review?
Melt sales objections with this book. I just got my black book of questions in the mail.
I'm looking at his discharge date, Your Honor. We can do 60 days, Your Honor, and we can discuss his discharge at that point. It can be before myself.
Before you? All right, thank you.
Yes, Your Honor.
December 4th, 2025 at 10 o'clock a.m. I'm sorry, 9 a.m. with the agent. Anything you wanted to say, Mr. Jane?
I'm not quite sure what was just determined on this review. I just know that I've been doing my best to try to check every box and fulfill all my obligations before this date.
Thank you. Anything from you, Ms. Woods?
No, Judge.
All right, so Mr. J, what was determined is that you did turn in your outpatient assessment information like you were supposed to, and that you've been doing everything that you're supposed to be doing. What needs to happen is you need to have the time for you to be eligible for early discharge to come up. You're not eligible quite yet, so we're putting it out in front of the probation agent for him to make that determination in front of him, and then he'll take a look at when you're eligible for discharge and discharge you if you become eligible for early discharge. Okay?
Okay.
Any other questions? You seem a little confused.
Yeah, I mean, everything that I was asked to complete has been completed. And so what am I to anticipate between now and December 4th?
Well, I think what needs to happen, like I just said, is you have to complete at least half of your term before you're eligible for early discharge.
Oh, okay.
So you're waiting for that time period to come up, sir.
Okay.
All right.
Understood.
But you still have to not have any violations of your probation at all, no, new charges or anything like that. Okay.
Sure.
All right.
Okay.
And then your next time you've got to see the agent and he can discharge you. Okay.
Okay.
All right. Any other?
Yes.
There we go. So that's it for today. That's Judge Erane Washington. I was going to go all the way, but I'm not going to do that today. Tomorrow is Judge Manning, I believe. Tomorrow is Judge Alex Manning, yes. So that's it for today. I hope you guys are really enjoying this content. Or am I just blowing smoke? Which I'm trying to quit smoking. If you like this content and you're not a subscriber to this channel, please consider subscribing to this channel. When you subscribe to this channel, you're joining my platform and my channel, and you're helping my channel and my platform grow. Don't forget to hit the like button, you guys. So that's it for today. I will see you guys tomorrow at 3 o'clock p.m. for Judge Alex Manning. You all have a wonderful evening. Ciao, ciao, ta-ta, and I will see you again soon.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel, fix it, Daniel, make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, I was standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's